Chapter 5 Silent Feature of the Indian Constitution. The Constitution of India is among the longest in the world. It continued the constitution development that took place under the British, retaining the basic perception of the Government of India Act of 1935 and taking from it approximately 250 articles verbatim or with minor changes. When India gained independence, the Constitution Assembly, functioning under a modified Government of India Act of 1935, became the provincial parliament. Its fundamental task, however, remained that of framing the constitution. Dr. Ambedkar chaired the drafting committee, steered the document through nearly a year of debate over its various provisions. Four leaders, Nehru, Patel, Prasad, and Maulana Azad, over its various provisions. Four leaders, Azad, through through their commanding grip on the Congress Assembly Party and Assembly Aid Committee, constituted a virtual oligarchy within the assembly. Issues were openly debated, but the influence of the Congress leaders was nearly irrespectable, although they themselves were by no means always of one mind. They sought to promote consensus, and in the end of the constitution was adopted by acclamation on January 26, 1915, the Republic Day. The new constitution went into effect. The new India was to be a parliamentary democracy, federal, republican, and secular. There were some members of assembly who pushed for a Gandhian constitution, one that would provide for decentralization state with village panchayat as its nucleus. The vast majority, however, were committed from the beginning to a centralized parliamentary government. Indian Constitution silent feature. Dr. Subhas Kashyap observed the Constitution is of India is the most comprehensive document. It is a unique. It in many ways, it cannot be fitted in any particular mold or model. It is a blend of rigid and flexible, federal and unitary, and presidential and parliamentary. It attempts a balance between the fundamental right of the individual on the one hand and the social economic interest of the people and security of the state on the other. Also, it presents a via media between the principle of parliamentary sovereignty and judicial supremacy. The following are the outstanding feature of the Indian Constitution. First, a written constitution of the Republic of India was a written and enacted constitution. It contained 395 articles divided into 22 parts, 12 schedule, and 3 appendix. In it present from it cover 319 Ottawa page. Like the Constitution of United States of America, Canada, and France, India too has a written constitution, though it differs from the document in many respects. Second, the longest non-constitution. The Constitution of India has the distinction of being the most lengthy and detailed constitutional document the world has so far produced. The original Constitution contribute as many as 395 articles and 8 schedules, to which additional were made by the subsequent amendment. Even after the repeal of the several provisions, it still contained 395 articles and 12 schedules. It has been endeavor of the framers of the Constitution to provide for the solution of all the problems of administration and governance of the country. Even those matters which are subject of the convention in other countries have been put down in a black and white. Thus, while the U.S. Constitution originally comprises only 7 articles, the Australian 128 articles, the Canadian 147 articles of India in original from the consist of 395 articles divided into 22 parts and 8 schedules. As a result of some amendment made since then, some new articles have been added, and some old ones repealed. The number of schedules has also risen. The bulk of the constitution continued to be still increasing. The extraordinary bulk of the constitution is due to several reasons. The Constitutional Assembly wanted to incorporate in the constitutional the accumulated experiences gathering from the working of all constitution of the world, and to avoid all possible defect and loopholes thereof. The extraordinary bulk of the constitution is due to several reasons. First, the constitutional assembly wanted to incorporate the constitution in the accumulated experiences gathering from the working of all the constitution of the world, and to avoid all possible defect and loopholes thereof. Second, in addition to the union, in included the constitution of the state. Also, the American federal constitution cover only the organization of the national government, leaving state constitutions to be framed by the state themselves. See, it details the distribution of the legislative, administrative, and financial powers between the union and the state. D. The vastness of the country and the peculiar problems to be solved have also contributed toward the bulk of the constitution. Thus, there is a one entire part 16 related to the schedule castes and tribe and other backward classes. One part 8 related to official language, related to emergency and another part 18 and Part 18th relating to emergency provisions. Fifth, since all the unit of the Indian Union are not of the same type, the Constitution had to make provisions for the all distinct type of special provisions had been inserted to meet the regional problems and demand in certain states such as Nagaland, Assam, Manipur, Sikkim, and Mizoram. F. The Constitution carries an elaborate chapter on fundamental rights, each right being accompanied by a detailed statement of restrictions imposed thereon. G. It also includes a chapter of fundamental duties. H. Beside a complete chapter of Constitution deals with non-judicial directive principle of state policies. It is sometimes asked why the framers of the Indian Constitution deemed it necessary to draw up such a ponderous constitutional document and ignore what Sir Ivor Generin had described as a golden rule for the all constitution makers, which never to put in anything that can be safely left out. The answer, as Sir Ivor has himself pointed out, is that the great volume of the Indian Constitution is largely a legacy of the past. The British government had set the fashion by the framing, largely a legacy of the past. The British government had set the fashion by framing lengthy and detailed constitution for India. In enacting the Government of India Act of 1919 and 1935, the 1935 Act was in fact the longest measure ever passed by the British Parliament. The new Constitution of India is like the Act of 1935, not merely a constitution but also a detailed legal code dealing with all important aspects of the constitutional and administrative system of the country. Third, popular sovereignty. The Constitution proclaimed the sovereignty of the people in its opening word. The preamble begins with the word We are the people of India, having the solemnly resolved to continue India as into a sovereign secular, sovereign socialist secular democratic republic. The idea is reaffirmed in several places in the Constitution, particularly in the chapter dealing with election. Article 325 declared that the elections to the House of the People and to the Legislative Assembly of every state shall be on basis of adult suffrages. As a result, government at the center and in the state drive their authority from the people who choose their representative for parliament and the state legislature is regular interval. Further, those who wield the executive power of the government are responsible to the legislature and through them to the people. Thus, in the affairs of the state, it is the will of the people that prevail ultimately, and that this is the principle of popular sovereignty. Fourth, the sovereign democratic republic. The preamble of the Constitution declares India to be a sovereign democratic republic. It is a sovereign since India has emergence as a completely independent state. The dominion status of India established under the Independence Act of 1947 has been terminated, and India is now a full-fledged state with all the characteristics of sovereignty. The word democratic signifies that the real power emerge from, emerge, emanates from the people. The Constitution introduced universal adult franchise and confer on the adult population of the country the right to elect their representative for the union parliament and the state legislature at the first of the periodic election to be held every 5 years. The word republic is used to denote that the state is headed not only by the permanent head like a queen of Britain, but the president indirectly elected by the people. Fifth, both rigid and the flexible. The Indian constitution is a partly rigid and partially flexible. The procedure laid down by the Constitution for its amendment is neither very easy as in England, nor very rigid as in the United States. In England, which has no written constitution, there is no difference between a constitutional law and an ordinary one. The constitutional law can be amended exactly in the same manner in which ordinary legislation is passed on amendment in the United States. However, the method of constitutional amendment is highly rigid. It can be carried out only with the agreement of the two-third majority of the Congress and its subsequent ratification by the least three-fourths of the state. The Constitution of the India strikes a golden mean thereby avoiding the extreme flexibility of the English Constitution and the extreme rigidity of the American Constitution. It is only the amendment of few of the provision of the Constitution had the required ratification by the state legislation, and even then ratification by only one upon two of them. One upon two of them would one one upon two them of them would suffrage, while the American Constitution require ratification of three upon four of the state. Uh, the rest of the Constitution may be amended by a special majority of the Union Parliament. Example, majority of not less than 2 upon 3 of the members of each House is present and voting, which again must be majority of the total membership of the House. On the other hand, Parliament has been given the power to alter or modify many of the provision of the Constitution by simple majority, as it required for the general legislation by laying down in the Constitution that such changes shall not be deemed to be amended of the Constitution. The very fact that within a period of 62 years of the Constitution that had been amended 95 times proves that the Constitution is flexible. It should, for however, it noted that the basic structure of the Constitution cannot be amended. Six, cabinet government. The Constitution established a cabinet type of government both at the central and in the unit. The most distinctive feature of the cabinet system of the government is the complete and the condition responsibilities of the executives of the legislature. The cabinet is composed of the prime minister, who is the chief of the executive, and his senior colleagues who share the responsibilities with the responsibilities with him for the formulation and execution of the policies of the government. Under the cabinet system, the head of the state occupies a position of the great dignity, but practically all authorities nominally vested in him is exercised by the cabinet or the ministry, which assumes full responsibility for acts performed in his name. The unity and collective responsibility of the cabinet and achieved through the prime minister, who is the keystone of the cabinet. Of the real merit of the cabinet system is that the executive, being responsible to the legislature, is always being watched. The moment it proves unequal to the task, or it goes off the track of the flute, the will of the legislation, the will of the legislature, it can be removed from the office by a successful vote of no confidence. Seven, secular state. By adding the word secular to the existing description of the country as a sovereign democratic republic in the preamble, the commitment to the goal of the secular has been spelled out in a clear term. A secular state has negative and positive aspect. Negatively, it is antithesis of the communal or the theocratic state, which officially identify itself with a particular region. Pakistan, for instance, has proclaimed itself as an Islamic state in a secular state. On the other hand, there is no official or state religion in its positive aspect. A secular state treated all its citizens alike and give them equal opportunities. According to the Professor Alexandro Wizard, India as a secular state guaranteed constitutionally guaranteed constitutionally freedom of the religion to all persons, and does not assign a special position to any particular religion. The state has no official religion. No discrimination can be made on the basis of the religion, faith, caste, color, sex, and every citizen is equal before the law. It guaranteed to the religious minorities the right to maintain their own language and to establish educational institutions to their choices. An important manifestation of secular in India is the abolition of the communal electorate and the adaptation of the provision that elections are to be held on the basis of the universal franchise and joint electorates. Eight, a federal system with a unitary biases. Perhaps the most remarkable achievement of the Indian Constitution is to confer upon the federal system and strength of a unitary government. Though normally the system of government is federal, the Constitution enables the federation to be transformed into a unitary state. The Constitution of India established a federal polity created by which has been created by dividing the country into state and allocating them function as specified in the constitution. Like all other federation, India has a written constitutions which is rigid to a large extent. There is a dual polity and division of the power between the center and state. There is also provision for the Supreme Court, which is the guarantee of the constitution and decided all dispute which might arise between the center and the states. These characteristic of the federal setup, the notwithstanding, the Indian constitution has a unitary basis. For instance, after distributing the legislative power in the three list, residual subject are left with the union, and even in a matter in the concurrent list, union government has been final says. Unlike the federation, parliament in India has the right to change the boundaries of the states. The head of the state, example the governor, are the appointed by the president and are his agent in the state. The center can at any time declare emergency in the state, and with the declaration can be take over the administration of the state in its own control. The choice of the federalism declare emergency as a state in the declaration, and with the declaration and take over administration of the state in its own control. The choice of federalism as a constitutional form and on the on sorry as the basis of the national government in India was not a sudden development upon the transfer of power on August 15, 1947. It was there for many years, and in a limited forms it was already in operation in British India for the solution of the constitutional problems of a multi-social multilingual and multi-communal country like India with a vast area and a huge population. Federalism was only a natural choice. Nevertheless, the framers were cautioned to ensure that the unity that sought to establish through the federalism was of an abiding nature, and in case of future conflict between that the unity and diversity preserved under the constitutions, the former should prevail over the latter. In other words, it was their intention to create an indestructible union and the supremacy of the union over the state in a number of matters vitally affecting the interest of the nation. Ninth, universal franchise without communal representation, the adaptation of the universal adult suffrages. Article 326 without any qualification either of sex, property, taxation, or like the is a bold experiment in India having regards to a vast extent of the country and its population with an overwhelming illiteracy. Yeah, the suffrages in India, it should be noted, is wider than that is in England or the United States. The concept of the population popular sovereignty, which underlines the declaration in the preamble that the constitution is adopted and given by the people of India upon themselves, would indeed have been hollow unless the franchisee, the only effective medium of the population sovereignty in a modern democracy, were extended to the entire population, which was capable of exercising the right and independent electorate machinery under the control of the commissions was set up to ensure the free exercise of it. No less creditable for the framers of the constitution is the abolition of the communal representative, which in its trail had brought into the bloodily and lamentable partition of India. In the constitution, there was no reservation of seat except for the scheduled caste and the tribes, and for the Anglo-Indians, and that only for a temporary period. 10 compromise between judicial review and the parliamentary supremacy. Parliament in India is not a supreme as the British Parliament. At the same time, judiciary in India is not supreme as in the United States of America, which recognize no limit on the scope of the judicial review. The Indian Constitution wonderly and adopts the via media between the American system of judicial supremacy and the English principle of parliamentary system by the endowing the judiciary with the power of declaring a law as unconstitutional if it is beyond the competence of the legislature according to the distribution of power provided by the constitution, or if it is in the contravention of the fundamental rights guaranteed by the constitution, but at the same time depriving the the judiciary of any power of judicial review of the wisdom of legislature policy. Thus, it has avoided expressions like due expression like due process and made fundamental rights such as that of liberty and property subject to regulation by the legislature. Further the major portion of the constitution is liable to be amended by the Union Parliament or by a special majority. If in any case of the judiciary proves to better expression than in the world of Jawaharlal Nehru, no Supreme Court, no judiciary can stand in a judgment over a sovereign will of Parliament representing the will of the entire community. It can pull up the sovereign will if it goes down wrong, but in the ultimate analysis where the future of the community is concerned, no judicially can come in the way. Ultimately, the fact remains that the legislation must be supreme and must not be interfered with by the court of the law in such measures as the social reforms, 11 single citizenship all through the India as a federal government, yet double citizenship as provided for in the U.S. Constitution has not been provided for all the Indians irrespective of their domicile enjoy a single citizenship of India, whereas in United States of all the citizens enjoy the right to double citizenship since American are considered to be the citizens of the state where they are domiciled, and then they are citizens of the USA as a whole. In both these capacities, they enjoy different rights and owe different obligation. The principle of the single citizenship was provided for in the Indian Constitution in order to foster a strong bond of the social and the political unity among the people of India who are the heteroto divided an account of racial discrimination, variety of the language, and multiplicity of the religion and cultural background. 12. Independence of judiciary. The framers of the constitution were aware that the democratic freedom were meaningless in the absence of an independent machinery to safeguard them. No subordinate or agent of the government could be trusted to be just and impartial in judging the merits of the conflict in which the government itself was a party. Similarly, a judiciary subordinate of the center or the state could not be trusted as an impartial arbitrary of the conflict and controversies between the center and the state. These were compiling reason for creation of independent judiciary as an integral part of the constitution, and for and for the adaptation of the judicial independence as the basic principle of the constitution. In its bid of the established complete independence of the judiciary, the constitution has the first erected a wall of separation between the execution and the judiciary. After effecting such separation, it has created conditions that are conductive to the making the judiciary independent. Thus, rigid qualifications are laid down for the appointment of the judges, and the provision has been made for compulsory consultation of the Chief Justice of India in the appointment of every judge of the Supreme Court and the High Court. They are given high salaries, and their condition of the service cannot be altered to their disadvantage, and their conduct is made a subject beyond the scope of the discussion in the legislature. They can be they can be removed from the office only for proved misbehavior. For this purpose, both the Houses of Parliament will have to pass resolutions against a judge supported by the two-third majority of those who sit on the board, and at least or absolute majority of the total membership of the House. Dual citizenship for NRIs. WHO left after January 26, 1919 15. The Citizenship Amendment Act Ordinance 2005 was promulgated, paving the way for the dual citizenship by amending the Citizenship Act 1955. It will bestowed eligibility for registration as overseas citizen of India (OCI) on person of Indian origin who or whose grandparents migrated from India after January 26, 1915, or were eligible to become an Indian citizen on January 26, 1915, or belong to a territory had that become a part of Indian after 15 August 1947, and their minor child who is the national of he is the sorry after who is a national of the country and that allow dual citizenship in some form of or the other. Dual citizenship allow the person to live in India indefinitely, unlike the person of India origin PIO card, which permitted a single stay of a person six for a period of 6 months. Dual citizenship do not have voting right, neither can they be elected to public choices as per the amended a law. Person of the Indian origin who were citizens of the Australian, Canadian, Finland, France, Greece, Ireland, Israel, Italy, Netherlands, New Zealand, Portugal, Cyprus, Sweden, Switzerland, United Kingdom, United States were eligible to apply for dual citizenship. Fundamental rights like the Constitution of the United States of America, the Constitution of India also include separate chapter guaranteeing the fundamental right of the all to the all citizens. These rights are justifiable and inviolable. They are binding on the legislature as well as on the executive. If any of the right is violated, a citizen has the right to seek the protection of the judiciary. Any act of the legislature or order of the execution can be declared null and void if it violate any of the fundamental rights guaranteed to the citizen of the Constitution. 14th fundamental duties, another feature which was not in the original constitution, not has been introduced by the 42nd amendment 1976 by introducing article 15a as a part, has been introduced by the 42nd amendment 1976 by introducing article 15(1)a as a part of 4th a of the constitution. The 42nd amendment act introducing fundamental duties to circumscribe the fundamental rights, even though the duties as such cannot be judicially enforced. The incorporation of the fundamental duties in the constitution was thus an attempt to balance the individual civic freedom with civic obligation, and thus to fill a secure gap in a constitution between directive principle of the state policy. The directive principle of the state policy is another distinctive feature of the Indian constitution. The feature has been taken from Irish constitution. The philosophy behind the directive principle is that the state and every one of its agencies are commanded to follow certain fundamental principles while they frame their policies regarding the various fields of the state activity. These principles, on the one hand, are assurance to the people as to what they can accept from the state, and on the other are directive to the government, central and the state, to establish and maintain a new social order in which justice, social, economic, and the political shall inform all the institutions of national life. Criticism of the Indian Constitution. The Constitution of India is remarkable for the many outstanding features which will distinguish it from the other constitutions, even though there were members in the Constitution Assembly who criticized the Constitution which was going to be adopted as a slavish imitation of the West, or the not suited to the genius of the people. Another assembly member charged that this constitution will not prove suitable and will break down soon after being brought into the operation. The main criticism level against the constitution are following. First, elephantine size of the constitution. The constitution of India is being criticized on the ground that it is most lengthy and detailed constitutional document the world has so far produced. In other words, of the ivory Jennings, the provision borrowed were not always well selected, and that the constitution, generally speaking, was too late and complicated. Second, the carbon copy of Act of 1935. The Constitution of India is called as a carbon copy of the Act of 1935. The father of the Constitution have borrowed a large number of the provision from the Act of 1935 and made them a part of the new Constitution, making a specific reference to this aspect of the Constitution. Constitution Ambedkar, the chairman of the drafting committee, said in the Constitution Assembly as to the accusation that the draft constitution that the draft constitution has reproduced a good part of the provision of the Government of India Act 1935. I make no apologies. There is nothing to be assumed in borrowing. Involves it involves no plagiarism. Nobody hold any patent right in the fundamental idea of the constitution.